Hey, Mr. B, long time no talk. Where in the world are you now?
Hello, I'm currently in Dubai. As you know, we announced the launch of our Riverstone Legal project a few days ago, which is our citizenship planners limb of Bukhari Chambers, or it's actually independent of it, but that's what I am doing in Dubai right now. So I've been very, very busy.
Tell me about it. No sleep for the BC team either. Whilst you've been away, the Home Office have also been busy making a new statement of changes announced on the
Mhm.
25th of June. I would like you to go through it with me, please, for our viewers. I'm sure they're all keen to see our thoughts and analysis of it.
I've got the explanatory memorandum open in front of me, which I'm going to go through and just give very quick summaries of everything that has happened. So, as you rightly said, 24th of June, 2025, that was yesterday that it was announced. And what it's doing is it's made a few changes. These are not monumental changes, but for some, these are life-changing changes. So we are going to go through that. So why don't we go through this document together and we can then talk about it? What do you say?
Yes, I would love to do that. Okay,
Okay.
if we start with the changes to Appendix Long Residence.
Okay, so this is paragraph 5.3 of the explanatory memorandum. What it's saying is that the qualifying requirements are being changed to clarify what the time spent would count as. Now, this might at the first instance seem very confusing or difficult to understand. It really isn't. What they're doing is what they've said is that if you were granted British citizenship and then you were later deprived, or there was a reason why you did not have British citizenship anymore, then that time that you've spent on that will be or will not be used towards a qualifying period, as in 10 years qualifying period to apply for indefinite leave. So, what they've said very clearly is um, time spent as a British citizen is considered lawful presence, except where the British citizenship has subsequently been deprived. So, if you have actually given up your citizenship, then that time period can be utilized as legal time period. But if you were deprived of your citizenship, then the time period that you spent on that will not be counted. So, just to give an example, we recently did a case, and this was an appeal that we handled, where a family of four, they had come to the UK and they had claimed asylum. They had claimed under a different name, which was not their original name. And what happened with that? They were granted asylum. They got their indefinite leave after that 5 year period. They got their nationality after another year. And then they spent a few years on that. And what happened later on when it was time to apply for an extension, or maybe somebody said something, the renewal, or somebody reported them, the Home Office found out that they had actually lied about their names and about their nationality and about their dates of entry, etc. When that happened, they deprived them of their citizenship. So the next question was, would they still get their status in the UK? Would they still be allowed to stay in the UK? And that is the point that we were dealing with. So we were able to get them indefinite leave to remain on the basis that they had spent continuous 10 years in the UK. Now that thing has changed. What they're now saying is that if you were deprived of your British citizenship, then whatever time that you have spent on that British citizenship, which you were not entitled to, will not be counted as legal residence. That's what this is saying. Okay, let's go on to the next one.
Okay, understood. The next one is 5.4, Appendix
Mhm.
Continuous Residence. So, what are the changes that they are proposing here?
Well, continuous residence, what they're saying is number one, when you're talking about continuous residence, they say that if you've been away for less than 180 days, then that will not be counted as a gap. So let me just clarify that. When somebody has legal status in the country, for example, somebody's visa is running out on the 30th of June, 2025. If they were to leave on the 28th of June, whilst they still have a couple of days remaining on their visa, and then they were able to go back to their country, apply for a new visa, come back within 6 months, then that period of 6 months, or well, less than 6 months, will not be counted as going against the continuous residence period if they want to apply for 10 years continuous residence at the end of the 10-year period. Do you understand? So
Yeah.
that's the point that they're making. The other thing they're also doing is that this is something which may not be relevant to a lot of people, but what they're saying is we will treat time with permission in the crown dependencies, which is the Isle of Man Isle of Jersey, and Guernsey on a route equivalent to those in the UK as lawful presence. So these are the crown dependencies where people, if they had spent time over there, that would not be counted towards legal continuous residence towards time spent in the UK. But now what they've clarified is that that is also included. It's generally, I'm happy to see that it's finally some bloody common sense coming in into these rules. It's not any, like I said, life changing or ground shaking rules that they have brought in. What they've done is a lot of common sense things that should have been there, a lot of mistakes that had been there in the previous rules, and a lot of idiocies that were there, they have now taken those away. So this is one of those things. Obviously, if the UK is the whole of UK, then why can't you treat time spent in the crown dependencies? Why can't you treat that time as legal time? So now that has been included as well.
No, I totally agree. I think this is a good thing. It reflects a more unified approach within the common travel areas, immigration regimes. I think this would be very helpful for loads of people.
Yeah, 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 absolutely. And the big one is the next one. Go on to
Yes.
that.
This is the next one. Changes to Appendix Private Life.
So this is something that I've been going crazy about for the past many years, where I say that if somebody who came to the UK, spent 7 years in the UK before they turned 18, were then granted leave to remain, and then they were granted a route well, they were granted leave on a 10-year route to settlement. How does it make sense to expect that child who has first spent 7 years and then is now on a different route, and then you say to them, spend another 10 years? How is that making sense? So this is the common sense approach now that has been brought into this. So what they're now saying is that if a child came to the UK while he was still under 18 years of age, spent 7 years and got his legal status on the basis that he's still under 18 years of age, has spent more than 7 years in the UK. If the child has been granted leave, then after 5 years of having spent legal status in the UK, that child will now be able to apply for indefinite leave to remain. This is big. So let's go through this again. I'm going to give it as an example again. So somebody who was 5 years old when they first arrived in the UK, they spent 7 years, the child I'm talking about, the child spent 7 years in the UK. And then by the time he was 12, he got his leave to remain in the UK. Now that child has spent more than 5 years living in the UK with continuous legal status. If that child is now over 18 years of age, you can now apply. Maybe 5 years was not right. Maybe it should have been 7 years. So if that child now, who came at the age of 7, spent another 7 years, now got 14 years in the UK, and 7 years in the UK, is now 14 years of age, and now has spent another 5 years. Now he's 19. So what the Home Office was saying before this changes came in was that that child had to still complete 10 years in order to get indefinite leave. So in these changes, what they're now saying is that that child would be eligible for indefinite leave after spending 5 years legally. Now, people might remember who are interested in these things that those young adults, this was a concession that was introduced in 2021. It became part of the rules in 2022, where they were saying that if you had been granted leave under the private life route, only then you would be able to apply for indefinite leave. And when I say this, a lot of people listening would be nodding their heads because their applications would have been refused when they made applications for their children who had spent 7 years, then legally 5 years, and then they made an application for indefinite leave and were refused on the basis that they were not last granted leave on the private life route. Now, those children who were granted leave under the child route will also be eligible for this. So this common sense approach, thank God for that, has now come in. What they're saying is that even those children who were granted leave on the child route and were granted leave before 2022 would still be included in this. So those kids, those children who possibly day before yesterday could not qualify for indefinite leave will now be able to qualify for indefinite leave. So let me just clarify this and for everybody's benefit. If your child came to the UK, was under 18 years of age, spent 7 years living in the UK, got leave to remain on the basis of spending 7 years living in the UK, and has spent 5 years on that, and is now over 18 years of age, he will be able to now apply for indefinite leave. So that's one thing very good about it. Second thing, you also know the rules talk about the half life requirement. So somebody who came to the UK and has spent more than half their lives in the UK, are over 18 years of age and still under 24, would be able to qualify for leave to remain. Now, again, my problem with that was somebody who spent more than half their life in the UK. You say to them, "We'll give you leave, but on a 10-year route to settlement." How does that make sense? So now the common sense approach has come in, and what they've said is those children or those young adults who were granted leave after they turned 18, who had spent more than half their lives in the UK, if they have spent 5 years living with valid leave, they can now apply for indefinite leave without having to wait for the full 10 years. So this is a very welcome kind of change, and I'm glad that they've done that.
Me too. Okay, next,
Yeah.
let's talk about EU settlement scheme and changes to the continuous qualifying period definition.
This is again one of those clarifications that they've made. What they've said is that people who would spend time outside the UK while they were on the EU settlement scheme, the pre-settled status, how long were they allowed to spend outside the UK? So those who have made such applications would know that if you had spent more than 180 days in one calendar year outside the UK, you would be refused. So the benefit of these changes for those people is that now what they're saying is that you can spend up to 30 months outside the UK in that full 5 year qualifying period. So if somebody was granted pre-settled status and they spent time outside the UK, whether it was because of an illness of a family member, because if it maybe because it was work or COVID or whatever, even if they've spent more than 6 months outside the country, as long as they've not spent more than 30 months in the total 5 year period, then they will still be able to apply for settlement. So that is what this 5.11 onwards is saying.
Okay, what about now 5.17 changes to make refusals of applications mandatory? Let's talk about that.
Yeah, well, this is a bit horrible. What they're now saying is that those people who have been granted status under the Refugee Convention or who were granted the humanitarian protection, if because of their criminality they were deprived of their status, now the rules are extremely strict about them. Now the rules are saying if anybody was granted a leave and then it was revoked or it was taken away from them on account of criminality or danger to the security of the country, then all their further applications are going to be refused. And if they have current leave in the UK, that leave is going to be refused or curtailed as well. So this is the draconian one, part 9. This is part 9 of the immigration rules, and what it is saying very clearly is that those people who engage in criminal behavior or who are antisocial or who have other criminal charges or who are a danger to the United Kingdom security, their applications will be refused. And if they have leave in the UK, those leaves will be curtailed or revoked. That's what it's saying.
Okay, and other minor changes you can comment on?
Well, there are a few minor changes, and this just breaks my heart. The minor changes are mostly dealing with errors in the previous drafting of rules. So, what they're saying is that in the previous rules, there were errors or omissions, and we are making changes so that those changes are now current, and that means that those omissions or those errors are corrected. Now, what my problem with that is we've been fighting in courts for many years for these errors and arguing that these are irrational, they do not make any sense, and they should not be there. But because they were part of the immigration rules, and the parliament at the time when these rules were introduced, the parliament at the time approved those rules. There was nothing the judges would do about it. There was nothing the Home Office would do about it. And there was nothing that we could do about it. So they've made certain changes in those. So they've taken those things away. Definitions, slight words here and there. I'm not going to go into those because those are just corrections. As and when the need arises, we'll talk about those. But apart from that, I would say the most important thing, looking at the whole picture as it is today, the main winners of this are the young people, are the children. So thank God for that, that they brought in a common sense approach to those people who are not through any fault of their own struggling. So a child who came with his parents, the parents are the ones who decided to become overstayers. The parents are the ones who decided to do anything that affected the child. So it was never the child's fault. So penalizing a child was always wrong. And this is what we always argued. And I've argued this many, many times before as well, that a child who has now been granted leave should be allowed to get settlement right away. So if a child is born in the UK, spent 7 years, is still under the age of 18, would get indefinite leave, even if the status is illegal. But a child who arrives at the age of, say, 6 months and spends 7 years in the UK will be granted leave on a 10-year route to settlement. How is that fair? So at least this changes a little bit. Now, that child who came to the UK at the age of 6 months, completed 7 years in the UK, got status on that basis, would be granted leave, and once that child has completed 5 years in the UK instead of 10 years, would be able to apply for settlement. So those children are the big winners. And of course, the young adults who spend more than half their life in the UK. Once they've spent more than half their lives in the UK and they're still under the ages of 24, then instead of having to spend 10 years to qualify for indefinite leave, they will now be able to qualify after spending 5 years, having spent half their lives in the UK. And this includes those people who were in the previous rules, meaning those people who were granted leave not under the private life route, but also the child route. So a lot of those refusals that people faced before can now become successful applications. So I believe we will need to make new applications for those people rather than expect the Home Office to correct their defects. I don't expect them to do that. I don't expect the Home Office to write to you and say, well, 3 years ago, we refused your child's application. Here we go. We are going to give you status now. I don't think that might happen. If it does happen, I'll be very happy. But if it doesn't happen, then you will need to make new applications.
Yes, I can't disagree there. Okay, thank you, Mr. B, for this great overview. When do these changes actually kick in?
Well, there are different dates for it, but for our purposes, these young children and the young adults, their changes come in on the 29th of July. So there are different dates for different things. We don't need to go into all of that because they become much more technical. For the main purposes, for those young adults and those children who want to apply for this, their changes will come into effect on the 29th of July, 2025.
Okay. I guess that's everything.
That is enough for today. Thank you very much. I
Yes.
know you've hunted me down even in Dubai to do this, but I'm glad you did because we hadn't done a video for a while, and these changes definitely require a proper explanation. So hopefully we've done that.
Yes, I hope so too. Thank you so much for listening. Make sure you subscribe to our YouTube channel. We will be posting our longer, more detailed videos on here, and of course, our shorts and simpler and more digestible ones on our TikTok and Instagram. And of course, to book a one-to-one consultation with our team and Mr. Bukhari, please go on our website, www.bukharichambers.com. See you in the next one.
Thank you very much. Bye.
Thank you. Goodbye.